States against Zambrano. Mr. Herbert.
Good morning. Good morning. May it please the court. My name is Dan Herbert, and I'm here on behalf of my client, Fernando Zambrano. And what brings us here today, Your Honors, is an appeal of a conviction which occurred in August 2022 against my client, Mr. Zambrano, for one count of providing false statements to the federal government. The counts, or the one count, were false statements, and the evidence clearly showed they were vague answers to vague questions. But nonetheless, that was a conviction of my client, who was a decorated police officer with absolutely no criminal background, a father, and he has already served his time here. We're going to ask, because of the significant errors that occurred at trial, before trial, and newly discovered evidence after trial, that the conviction be vacated. And I also will ask that I be allowed some time for rebuttal in this case. The issues, Your Honors, which bring us here are the errors at trial, which was a prosecutorial misconduct, suppressing favorable evidence to the defendant regarding...
I don't recall seeing prosecutorial misconduct being a theory in your brief. I thought you were making just a new trial, new impeaching evidence argument.
Yes, Your Honor, but it was based upon the prosecution's suppression of the favorable evidence regarding the key witness in this case, Agent Chesla.
Did I miss the arguments about prosecutorial misconduct?
They're in there, Your Honor.
Well, I apologize.
That's okay. So it's the prosecutorial misconduct regarding the...
You're saying there was deliberate prosecutorial misconduct?
Yes, Your Honor.
Okay.
And that's based upon the fact that we discovered evidence after the trial about the misconduct of Agent Chesla in a similar case in which he was found to have committed a perjury and obstructed justice. This information was known to the government at all times during the case involving Zambrano. Now, I will acknowledge that...
When did Judge Cannelli make his findings?
He made it after the verdict in our case.
So in what sense is this prosecutorial misconduct? Because
the government was aware of the misconduct that Chesla committed, and it wasn't... They didn't need the judge to tell them that there was misconduct in this case. The misconduct was committed by Chesla against various government agencies. He was providing benefits and withholding evidence from the Immigration Department, the ICE Department regarding witnesses.
And the prosecutors in this case knew about it?
Judge, my position is that they had to have known about this. I don't have any direct...
These are serious accusations, and it sounds like you have no evidence to back them up other than speculation about timing.
Well, Your Honor, with respect, there was no way that the government could not have known about the misconduct of Chesla because it was a situation where it was heavily litigated in the same courtroom. The same courthouse, and they were very serious accusations. And in the case with Mr. Zambrano, there's no question that Chesla was the star witness in this case. So, you know, in the evidence, it proves how much of an integral witness Mr. Chesla was. He was called 3 different times in this case by the government. So, no, I do not have direct evidence that the prosecutors in this case had direct knowledge of it. But I am saying that it's reasonable to infer that they should have had knowledge about this.
Does the record reveal how many cases witness Chesla was on besides Zambrano and decolata?
No, Your Honor, I don't believe that there was ever any evidence presented about the number of cases that he had.
Were you present at the decolata 7-day evidentiary hearing before Judge Cannelli?
I was not, Your Honor.
Do we have any understanding of how much time Mr. Chesla spent on the stand at that 7-day evidentiary hearing?
Your Honor, I don't know the answer to that question, but I know that that there was vigorous cross-examination as mentioned by Judge Cannelli in his ruling. And I'll be honest, my only knowledge about the decolata case is what I saw in Judge Cannelli's ruling. Otherwise, I don't have any knowledge about that case. Okay. Aside from the Chesla issue, which we believe is the main issue here, we also we take issue with the materiality instruction that was given by the court in this case at the close of evidence, and I'll explain why I believe that was prejudicial. It shouldn't have happened. And then the final issue is the court's response to various jury notes. It's, as Your Honors know, it's integral, bedrock of our foundation that a defendant receive a fair and impartial trial. And in this case, the consequences are not just an injustice to Fernando Zambrano, but it can be an injustice to all Americans.
Mr. Herbert, is there any, I understand, I think, at least your attack on Chesla, regardless of what prosecutors may or may not have known when about it. But as I understand it, the critical evidence here was all on tape. Is there any dispute as to whether Mr. Zambrano called, I guess it's Mr. Recchio, 3 times on 3 days about his contacts from the FBI?
There is no dispute about that.
Is there any dispute that Mr. Zambrano wanted to know what the FBI was asking Recchio?
There is no dispute about that.
And is there any dispute that Recchio was told by the defendant he did not have to talk to the FBI?
There is no dispute about that.
Nor is there any dispute that the defendant lied about his contacts with Recchio when he was interviewed by both Chesla and Weller, correct?
I would agree that he gave false statements, but obviously
given all of that, why is it, I guess I'm having trouble understanding how critical Chesla's credibility was in this, since Weller also could have testified in his stead and also testified.
Your Honor, the tapes alone in this case obviously were powerful evidence to show that Mr. Zambrano gave a false statement. There's no question about that. However, what was required to be proven was not just a false statement, but that the false statements were given willingly and they were material to the investigation. And the biggest point that we have pointed out and shown is that Mr. Zambrano's false statements were not material to the investigation that was in the indictment.
That's on the theory that the agents didn't believe him?
No, it's under the theory that that there was no $50,000 investigation at the time in which Mr. Zambrano was interrogated, which was the date of his false statements. So if there was no, the government tied this, they tied this case to a false statement that had the potential to impede an investigation into the unaccounted for missing $50,000. The phone calls do not mention anything about the unaccounted $50,000.
So what?
There was no investigation regarding the $50,000 unaccounted for money at the time of Mr. Zambrano's interrogation, which means...
So why was he being questioned?
He was being questioned just like every agent in his unit, because there was a criminal case that was being formed against this individual named Sabini.
Right. So his partner, right? Zambrano's partner, one of his coworkers.
One of his coworkers, yes.
So how crystalline informed does the target of the investigation have to be in order for interrogations as part of it to be material?
Well, There was no investigation, is my point, Your Honor.
There was an interrogation.
There was an interrogation.
There was an inquiry, right, into members of this task force?
It was into various deals, consignment deals and drug deals, yes, pertaining to.
Okay, I
some
guess I'm
cases
having
that were-
trouble understanding the theory behind your materiality argument.
I'll try and make it more clear. The government was required to prove that the statements were material to the investigation concerning the unaccounted for missing $50,000. That's how the indictment was drafted. It was not material to an investigation into Sabini. It was not material to an investigation into any other matters. It was material to the investigation into the missing $50,000. And Chesla is the only person that could provide the link to that investigation being active as of the date of the interrogation. And that's exactly how the jury instruction read, was that if you find that the statements were false and there was an investigation as of that date, you can find him guilty. And important in this case, I think, Your Honors, is that it's likely that this case would not have even gone to a jury had defendant been allowed to, or had defendant known about the misconduct of Chesla. In this case, as Your Honors know, there was significant pretrial motions done in this case. Rather unique. There was 2 motions to dismiss. I think it's unique anyways, filed prior to trial. Both of those were based on the misconduct of Chesla. This was all done prior to knowing about the significant impeachment of perjury and obstruction of justice. Chesla was the link to this missing $50,000 investigation. Nobody else, despite what the government says, but Chesla essentially created this $50,000 issue. He was the one that pulled the ROI, the investigative form. He provided the link for the email from Agent Heyer that cast some suspicion based upon some innocuous statements. Chesla was the one that testified to the jury that he spoke to Rescue about the $50,000. That's important because, again, the government had to prove that the interrogation of Zambrano, there was an active investigation. Rescue didn't testify. Chesla said, "Oh no, I talked to Rescue about the $50,000." There was no
Mr.
mention of
Herbert,
it.
if you wish to reserve any time for rebuttal, now would be a good time.
Thank you, Your Honor.
Ms. Alexakis.
Good morning. May it please the court. Georgia Alexakis representing the United States. The district court did not abuse its discretion here in denying defendant's motion for a new trial. The defendant's motion for a new trial was premised in part on adverse credibility determinations that were made more than a year after the jury trial here against case agent Tony Chesla in a separate, unrelated criminal proceeding involving a different defendant, Robert Decolita. There were no findings that Agent Chesla committed perjury. There were no findings that Agent Chesla committed an obstruction of justice. A jury cannot commit error by failing to consider evidence, in particular these adverse credibility determinations that did not exist at the time of trial, and the government cannot suppress evidence that did not exist at that time either. With respect to the defendant's motion for a new trial and its premise that allegations made against Agent Chesla with respect to the Decolita matter should have been disclosed, those allegations were made before the defendant's trial in this case. But as the district court concluded, ample evidence at the defendant's trial established his guilt, in particular that his false statements to federal agents were both willful and material, and that evidence, as Judge Hamilton said, was all on tape. That critical evidence was all on tape. It was separate and apart from any testimony provided against the defendant by Tony Chesla. In particular, the evidence establishing that Fernando Zambrano's lies were willful were, again, his own words as caught on tape, both in conversations with the source, Juan Recio, who recorded those conversations not at the direction of law enforcement, as well as in the recorded statements that he made during his April 2019 interview with Tony Chesla and Agent Weller. The juxtaposition of those recordings reflected Zambrano's lies. In addition, the jury heard testimony from a supervisor, Morrow, who testified with respect to the defendant's knowledge of the investigation, the fact that throughout 2018, Zambrano would have been put on notice of the investigation based on the dismissal of one of his cases with Agent Sabini, the fact that Agent Sabini was placed on administrative duty, and the fact that, as Agent Morrow testified, or Supervisor Morrow testified, by early 2019, the investigation was, quote, common knowledge. The jury also heard testimony from Supervisor Heyer, who's the individual who looked at the reports for the January 2017 drug deal in question. He looked at that in January of 2019, and that's the notification that the fact that Supervisor Heyer looked at those reports is what then set into motion a chain of events in which Zambrano then emails with Agent Sabini to discuss the import of the fact that someone outside their chain of command is looking at that investigation. So all of this, in addition to the fact that Zambrano himself is a law enforcement agent who would have known that lying to federal law enforcement is a federal crime, and the fact that Zambrano was warned about the fact that there was an investigation into his criminal misconduct before his April 2019 interview, all of that speaks to the willfulness behind Zambrano's lies to the agents in April 2019, and all of that is separate and apart from any evidence provided by Tony Chesla.
Ms. Alexakis, can you clarify for us what we're being told by your colleague is that at least as I understand it, the investigation alleged in the indictment had not yet taken shape at the time of the April 4th interview?
And I disagree with that representation, Judge Hamilton. I think the indictment alleges that there was an investigation into criminal violations by Fernando Zambrano and Agent Sabini, anonymized in the indictment. And then it specifically states, the indictment goes on to specifically state that the investigation encompassed an investigation into the unaccounted for $50,000. At trial, the jury heard from Agent Heyer, or Supervisor Heyer, who testified that in January of 2019, so 3 months before Fernando Zambrano was interviewed, he pulled the relevant documents regarding the January 2017 drug deal that is related to the unaccounted for $50,000. So that's one piece of evidence untethered to Agent Chesla that establishes that the $50,000 was within the scope of the investigation before Mr. Zambrano was interviewed. Another piece of evidence going to that point is the fact that Agent Weller testified that in March 2019, so 1 month before Mr. Zambrano was interviewed by agents, Agents Chesla and Weller showed Juan Recio the $50,000 transaction receipt. So the receipt that purported to show that Recio received $50,000 from Agent Sabini and Officer Zambrano for the January 2017 heroin deal. Now, I will say that Agent Weller's testimony was hamstrung by the lack of fluency that he had in the Spanish language, so he could not then testify without violating hearsay rules as to what Recio said in response to being shown the transaction receipt. Yet Weller was able to testify that the transaction receipt was shown to Recio, therefore further establishing that that $50,000 transaction was within the scope of the investigation before Mr. Zambrano was interviewed.
Inquiring minds want to know, have you all found the missing $50,000?
There's nothing in the record to reflect whether the $50,000 has been accounted for.
One of the arguments that you all make in your brief is, in essence, that impeaching evidence cannot support a new trial. And I wonder if that is not too broad and too categorical.
I think
as
it,
we've suggested in a case called Taglia, 922 F. 2nd at 416. And it's also hard to reconcile that kind of categorical rule, at least for me, with the broader Brady-Giglio line of cases.
yeah, and I think stated that way, it does strike me as too categorical as well. I think that there is language in the case law that talks about how impeaching evidence can be material in cases where a particular witness's testimony.
Language in the case law, that's the holding of United States against Aggers.
Yes, Judge. Yes. So I guess the way I would put the rule is typically, usually, impeaching evidence cannot be the basis for a new trial unless you have a situation in which a particular witness's testimony was exceptionally material to the verdict.
So that is less a categorical rule than an empirical generalization, subject to many exceptions.
Subject to at least one exception that the district court recognized here, recognized it in when denying the defendant's motion for a new trial. And I think accurately goes through the analysis to explain why Chesla's testimony here is in fact not the linchpin for Zambrano's conviction, and thereby distinguishing this case from other cases that the government cites and discusses in its response brief, in which a witness's testimony was in fact quite pivotal to securing the conviction. And so here, because there was evidence separate and apart from Agent Chesla with respect to materiality and willfulness, the confidence that we can have in the jury's verdict is not undermined by evidence of unsubstantiated allegations that of non-disclosure of benefits that have been made against Agent Chesla prior to Decolaitis trial. At best, those allegations would have been merely impeaching. In this case, they do not bear directly on the charge against Zambrano, and they would have had limited relevance and utility for the defendant as well. We're talking about allegations that are quite disconnected from Mr. Zambrano's case. There's no testimony in Mr. Zambrano's case from Recio or any other cooperator, unlike the case that we had involving Robert Decolaita. There's no allegation in this case that there were undisclosed benefits to testifying government witnesses. Indeed, as the defendant notes in his reply brief, he knew that Mr. Recio had been provided benefits in the form of legal status to remain in the United States, that had been disclosed to him. In fact, he had been part of the process because he had been working with Mr. Recio. The defendant had been part of the process of securing those benefits for Mr. Recio. And of course, defendant had ample opportunity to cross Agent Chesla throughout the trial, including on the fact that he had provided a piece of erroneous testimony to the grand jury. And so in light of this other evidence, in light of the merely impeaching nature of the allegations that had been made against Agent Chesla, and in light of the limited utility or relevance of those allegations to the matter involving Zambrano, the district court did not abuse its discretion in denying the motion for a new trial. And similarly, the district court did not err when it denied the motions to dismiss that the defendant filed earlier in the proceedings. I believe defense counsel said that both motions to dismiss were based on, quote, Chesla's misconduct. I don't think, again, that that's an accurate representation. The first motion to dismiss alleged that the indictment was legally defective and that it did not purport to set out all of the elements of an 1001 offense. The district court dispensed with that argument properly, and that argument had nothing to do with Agent Chesla. The first motion to dismiss also discussed whether the government had alleged sufficient facts to support a conviction against Chesla, a conviction against Zambrano. The district court dispatched with that argument properly by noting that these were factual arguments for a jury, not proper for a motion to dismiss. The first motion to dismiss also argued that Zambrano's statements during that April 2019 interview should have been suppressed as coerced. That had nothing to do with any allegations of misconduct by Chesla. It turned on a legal question as to whether or not Zambrano was in fact in custody for purposes of a Fifth Amendment analysis during the course of that April 4th interview. And so when defendant says that he would have prevailed on that first motion to dismiss, I think the facts strongly indicate, or the record strongly indicates otherwise. And with respect to the second motion to dismiss, that was an allegation that there had been misconduct in the grand jury tied to Chesla's testimony, Agent Chesla's testimony before the grand jury. And in particular, defendant pointed to, I believe it was 5 alleged misrepresentations that Agent Chesla made before the grand jury. The district court properly, after looking at the record of the grand jury proceeding, concluded that, well, I think it was 6 alleged misrepresentations, that 5 of those misrepresentations simply were not borne out by the transcript. And defendant hasn't argued on appeal that, in fact, his representations of what transpired in the grand jury were accurate. And so the district court's findings there should stand. And then the remaining allegation spoke to a factual error that the government admits that Agent Chesla made in the grand jury. But as the district court found, that mistake was immaterial from a factual standpoint. Agent Chesla testified erroneously that he thought that Zambrano was being untruthful during the April interview based on his review of Resio's phone records, when in fact Agent Chesla had not reviewed those phone records at the time that he had testified in the grand jury, and instead his belief that Zambrano had made false statements during the interview was based on Agent Chesla's interview of Resio. Factually, though, that doesn't matter. It's an immaterial mistake from the standpoint that Tony Chesla still had a basis to believe that Zambrano had been lying during the interview. And legally, it also doesn't matter because as the materiality instruction accurately told the jury, the agent's beliefs as to the falsity or truth of Zambrano's statements during the April interview have no bearing on the 1001 charge. Unless there are any further questions from the panel, the government will rest on its brief and ask that the district court's judgment be affirmed. Thank you.
Thank you, counsel. Anything further, Mr. Herbert?
Thank you. One point that Judge Hamilton raised about Mr. Zambrano telling Mr. Resio that he didn't have to speak with the government, I think it's important to note there that that does sound suspicious on its face, but there was ample testimony at the trial that Agent Zambrano is responsible for his confidential informant, and it's not as unusual as it sounds at first blush. With respect to the 2 motions to dismiss, with all due respect to counsel, that the first motion to dismiss was based significantly on Chesla, as well as the other points about the insufficiency of the indictment. It was based upon his violation of numerous Department of Homeland Security policies, which were...
What does that have to do with the validity of an indictment, given the legal standard of Bank of Nova Scotia?
That doesn't have to...
It doesn't have anything to do with the validity of an indictment.
You're right, Your Honor, but it was raised in more of a Brady-Giglio issue.
Which has nothing to do with the validity of an indictment.
And I agree 100%, Your Honor. Finally, we've talked a lot about Chesla. There's also 2 other instances which we believe warrant vacating the conviction in this case. The first one with respect to the jury instruction. With respect to materiality, that was obviously a big part of our case, was that the evidence did not speak to materiality. At the close of evidence, the government's entire theory leading up to the case or through the case was that Zambrano knew he was guilty, and that's why he gave these evasive false answers. Based upon, and this is in the record, there was significant impeachment of other witnesses that called into question whether or not those false statements were material to that 50,000.
Thank you, counsel.
I'm sorry?
Thank you, counsel.
Thank you.
The case is taken under advisement. We'll hear argument now in the case of United States against Hancock. Ms. Romay.
Good morning, Your Honors. May it please the Court. My name is Colleen Reme, and I am here on behalf of Patrick Hancock today. Passive resemblance alone does not a representation make. That is what we are asking this court to find. This case poses a simple question, despite the briefing. It comes down to whether or not dressing as a police officer with a subjective hope to deceive violates Indiana law. As I believe the government agrees, the question turns on the meaning of represents in the Indiana false impersonation statute. What we have here are facts found by the district court that essentially amount to someone dressing, albeit convincingly, as a police officer and shopping. We have no facts that were found that he had any interaction with any other human being or otherwise asserted himself as an officer. The district court said, you know, when Mr. Hancock objected to the finding that he had violated Indiana law, he said, you know, you have to do more than just wear a badge. The court said, yeah, you did more than just wear a badge, but didn't explain what he did. He actually, the actus reus of this crime. The bottom line is here that like I said,
Given how we expect civilians to respond to police officers and their presence,
sure.
Particularly in an age when civilians often have the right to carry firearms, why isn't it sufficient that the act in this case was putting on the uniform, or rather the badge, and the equipment, quite distinctive, recognizable as law enforcement?
Because, Your Honor, that isn't.
It's a nonverbal representation to the people, everybody he's going to be around.
Sure, and well, I wouldn't agree that it's a representation. It is a nonverbal. It communicates something. I agree with that. There is a communication. However, you need to have something more. So in this case, if this is enough, and then it's a mere lie, right? It is a mere falsehood. There is nothing more that is being done. So Mr. Hancock did nothing that would have affected anyone else's behavior around him, and simultaneously upon confrontation, he identified himself using his real name and told the police officers he was not a cop. So he never tried to exert any type of authority or do anything that an average citizen wouldn't be able to do as a police officer. In order to make this, to read this statute in a constitutional manner, you have to read represent as requiring some sort of interaction or engagement with another human being. And the jury instructions that Mr. Clark filed recently only support that reading. The jury instructions say that the defendant has to falsely represent himself to a specific person. That necessarily requires some affirmative act. It's not just he's susceptible of being mistaken for a police officer. When I was thinking about this case in preparation, it made me wonder, what if Mr. Hancock had never left his house? What if he was dressed identically to how he was found in Costco, but instead he hadn't left the house yet? And officers were looking for something, and they knocked on his door, and he opens the door and is standing there in full outfit, and he says, "Oh, I'm Patrick Hancock, I'm not a cop." Has he violated the Indiana statute when he hasn't left the house?
Let's assume the answer is no.
Right.
But he has left the house.
Okay.
He apparently has visited several Costco stores that day, and he is at least at the one in Avon, where it would be reasonable to expect everybody around him who notices him to think that he's a cop. Mm-hmm. And to behave accordingly. You remember the old David Crosby song, "Almost Cut My Hair"?
No.
Well, you may be a little young for it, but it goes back to the 70s, but it increases my paranoia like looking in my mirror and seeing a police car. So
Sure.
all of us have that kind of reaction, right?
Sure. And, you know, the question is, I guess there has to be a line drawn, and so is going out into public that line? I would argue that's not a rational place to draw the line, because I still believe that is a mere lie. So
Perhaps the distinction it's the character and attributes of the individual that are being presented. And what might draw a distinction here, which might not be to your client's advantage, is the gun and the badge versus a utility belt, a professional type uniform. Because individuals who go into Costco all the time and see security that wouldn't have the gun and the badge, but he did have the gun and the badge. Isn't that a problem for him?
that just, in my opinion, that just goes to the authenticity of his costume, to the believability of it, which I believe the district court correctly inferred intent to deceive. You know, if he was wearing a sticker that said sheriff on it, and that was it, we might not be able to infer that he really intended for people to believe that he was a sheriff. So the fact that it was a believable costume versus a non-authentic costume indicates an intent. It doesn't add to the actus reus here, and so it doesn't change what he did. And what he did was just exist in this costume and walk around. So then the question would be, well, what if he was in a park dressed as a cop? What if he was in his backyard? Is that public enough? I mean, you get to these bizarre questions of where the line is. And
So where do you think it should be?
the line I think it should be is that you need to engage in some sort of interaction with someone. So, I mean, there is no one in the facts here that we have that he made a representation to.
What's your best Indiana authority for that proposition?
Indiana, as discussed in the briefs, there really isn't any Indiana case law on point to exactly what representation means. All of the Indiana case law that I was able to find on this statute is consistent with my
If there's no Indiana
interpretation.
case law, then we have a district judge who just takes the Indiana statute as written without making up extra rules. What's wrong?
Well, the problem is that the way that this is interpreted under the government's reading and the way the district court applied it criminalizes mere lies. And that is what Alvarez says is unconstitutional. Everywhere it's been applied in Indiana, it's not been a mere lie. So Indiana's actual application of the law is not.
So do you think our decision in Bonin is incorrect?
Excuse me, I'm sorry.
Do you think our decision in Bonin needs to be overruled
No, Your Honor.
as inconsistent with Alvarez?
No, Your Honor.
So how is the state statute different from the one we said in Bonin was valid?
If the government's version, if the government and the district court's interpretation of it is correct, then the state statute doesn't have the acts as such requirement. So the acts as such requirement in Bonin, like in the federal statute 912, requires not only pretense, but the acts as such. And Bonin said that acts as such brings this within makes it past constitutional muster. It says it requires an intentional action in the pretended character sought to cause the deceived person to follow some course he would not have pursued but for the deceitful conduct. We don't have that in this case.
I don't see what's missing here.
We don't have any action that
You
he
dress
sought
up
to.
as an officer and walk around and act like an officer. That's certainly intentional.
And there is no person that he has sought to deceive to follow a course of conduct. I did want to address Judge Hamilton's point about, he's maybe gone to other Costco's that day. I don't believe the record is clear that he was visiting other Costco's in that same day. My review of the record indicated that he resembled, to some extent, someone who had been passing bad checks at Costco. They suspected him of being this person. I didn't see.
He has a long record of passing bad checks.
Oh, sure, yeah, absolutely. And he has other instances where he has actually falsely represented himself.
Yes.
But every time you look at any of those convictions, he has actively asked someone to comply with his orders, or he's tried to obtain something from this false presentation of himself as an officer. In this case, there isn't any evidence that while he was carrying the gun, he made any active representation of himself to another person. And that is why the court should vacate his sentence and remand for resentencing.
Could I ask you, Mr. Ray, you seem to be asking us, at least in part, to declare the state statute unconstitutional. It would be very odd to do that
Sure.
in this procedural process,
Absolutely.
among other things, without any input from the Indiana Attorney General.
That's fair, Your Honor. I think the cleanest way to resolve this case is to hold that, as we've been discussing, representation requires an affirmative act more than just dressing in a costume. And then I think that then it's a much closer question as to whether or not this statute is constitutional. And it arguably much more closely tracks the federal statute. Without it, essentially the reason that there is this constitutional argument in there is because if we interpret it the way that it has been applied in this case, it really does cause these constitutional issues of criminalizing mere lies to the extent that you're communicating anything just by dressing in a costume. And if there are no further questions at the moment, I'll reserve the remainder of my time for a follow-up.
Certainly, counsel.
Thank you.
Mr. Clark.
Colin Clark on behalf of the United States. I'd like to touch on something Judge Hamilton mentioned before getting to my more or less canned opening. Under 28 U.S.C. 2403B, this court may choose to invite the Indiana Attorney General's office to intervene to defend the constitutionality of its own state's law. This court has the power to do that. But let's start with the big question. What is representation? I was walking home after working on this case to the garage where I parked my car, which is a few blocks away, and I saw a protest about the Middle East. There were about 100 people in the crowd, no David Crosby, and I saw 2 police cars and 4 or 5 police officers in the road, and the police officers in full uniform were simply leaning against their cars. And I got to thinking about, well, what are they doing? They're just standing there. And I believe what they were doing is they were displaying authority, the state-sanctioned authority to kill at a moment's notice. That is expressive conduct. There's speech and non-speech elements to it. And it's an expression that any 6 or 86-year-old would understand. It's the simultaneous display, Judge Brennan, of a badge and a gun. People know what that means. When Dirty Harry is suspended, what's he asked to turn in? The 2 markers of what a police officer is. There are absolutely going to be gray lines as to what constitutes representation. That is, impersonating, as the title of the law suggests, impersonating a police officer. That display is enough. And it is a compelling state interest. Indiana has an intense state interest in preventing the interference with the integrity of government processes. That is the protection of law and order in public spaces. Go to a mall, an airport, a movie theater. You're going to see police officers there just simply existing because they display authority. Now think about what you might do in a situation where there's a robbery or, God forbid, a mass shooting, where seconds count. If someone runs up to a guy like Mr. Bonin or Patrick Hancock in an emergency, what are they going to do? Hancock is a felon with a gun. and seconds count. And in the Bonin case, there was an off-duty police officer working that movie theater that night. What if they had wasted that critical time by going to the fake cop instead of the real one? Now, the key to Alvarez, in my reading of it, was the availability of counterspeech to fix the problem. You can simply post on the internet who won the Medal of Honor. And even if that's tough, you can basically do that. To the grandmother in the movie theater who's running up to a Patrick Hancock asking for protection in an emergency, what counterspeech could possibly be offered to her? And even if we could post an internet site containing the stats of all of the local police officers, is that even a good idea considering the security concerns that would create? I'm sure most police officers would not want that in the public sphere.
Mr. Clark, you sent us the Indiana pattern jury instructions with an element falsely represented to blank, name person alleged. How would you fill that in this case?
Employees and customers of Costco, and I'd like to point this court to the Ferry case, Ferry versus State, which is an Indiana Court of Appeals case, and I will admit, this is something that they mentioned in passing. It's not a holding of the case, but if they discuss this very pattern jury instruction, and I'm looking at 124 Northeast 3rd at page 116, and the way that trial judge wrote that instruction in, number 3, falsely represented to employees at the Hamilton Center, Inc. And so, yes, you absolutely must represent that you are a police officer to another person. However, that person does not need to be a specific named individual, as I understand Indiana law. But again, I have not, this is not something that Indiana courts have particularly fleshed out. I just think that that's the most reasonable way to read the statute because, again, the gravamen deals with impersonation. And so when you are impersonating, anyone who can see you is affected by your choice to display the badge and the gun.
So the defense tells us that's going to lead to all kinds of terrible confusion involving actors and exotic dancers and so on. Your thoughts?
Well, they knighted Sir Laurence Olivier for acting. They didn't arrest him for it. I think that I could go to the Tomsha case. I could go to the Alvarez case. I could go to the Bonin case. I think in every single...
What are you going to do when you go to these cases?
I'm going to reference them. I'm sorry, sir. It's a verbal tick that's unfortunate. Referencing those few cases, they all mention the availability of trick-or-treaters and the like, and people on a stage. And at the end of the day, they are not representing facts about themselves that they expect the others to believe. At the heart of parody or trick-or-treating or acting is the desire to temporarily trick the receiver of that communication and then to allow them to feel gullible once the sort of rug is pulled out from under them. And so the idea that if I tried to deceive my neighbor by dressing up like a police officer on Halloween, if I did that in a way that intended to deceive them, I'm not going to get candy. I'm not going to get a standing ovation at the theater. The intent to deceive separates those, what I believe the Chappell case called ludicrous types of hypotheticals, and what might actually happen in the real world. So with that, I'm going to move quickly to the narrow tailoring piece of this. In order for a statute to fail on First Amendment narrow tailoring grounds, I understand the cases to require that the alternative restriction be offered to the state that is 1, constitutional, 2, less restrictive, and 3, would at least be as effective in achieving the legitimate purpose being served. I hear of no alternative restriction that would be at least as effective. Here, I'm told by my esteemed colleague that that you must act as a police officer in order to make it sort of within the bounds of free speech. I don't understand any of the cases to have that requirement. I don't know where that might even come from. In fact, when we talk about Alvarez, and I'm quoting briefly from the plurality opinion, and it's talking about the federal impersonation statute, it says even if that statute may not require proving an actual financial or property loss resulting from the deception, the statute itself is confined to maintaining the general good repute and dignity of government service itself. And so what we're talking about here is the interference with the office of government. And think about this in the context of, say, a 1001 prosecution where there is no fraud. There's but a false statement, but that false statement interferes with the government process. That is constitutional under the First Amendment. There's no act required under 18 U.S.C. 1001. It's but a word. And also, again, because this is expressive conduct, I don't even think we reach the strict scrutiny that this court decided that it didn't reach the question, but it said it would be constitutional under either. If the court needs to reach the question, we firmly believe that it is expressive conduct under cases like O'Brien, not the higher form. To move briefly to the Beckles issue, which I think is the knottiest piece of this case, I mentioned the prudential concern of the wrong sovereign defending the statute. I also mentioned that we waived, as the United States, our plain error argument on the First Amendment issue. This is a broad guideline that captures every American felony, and it doesn't require a conviction. It requires only that the offense, the weapons offense under 2K2, to be done in connection with some other American felony. And that's a pretty broad guideline. And in the sentencing context, what is available to the defendant in terms of process is different in nearly every way to what a traditional conviction might allow that person to attack. There is, generally speaking, no availability of a motion to suppress. There's no apprendi requirement. There's no indictment, no grand jury, no speedy trial, and no confrontation. And traditionally, you cannot collaterally attack the convictions in your criminal history. So to assume that this must be an availability, an avenue that Mr. Hancock may raise, it does not seem like the logical conclusion based on this court's other cases, albeit none of them, strictly speaking, on point. And if Mr. Hancock, after he gets out of prison and is done with his supervision, wants to file a 1983 action and attaches PSR and an affidavit saying, I want to do it again, he'll certainly have standing under the 1983 context to attack given the Indiana's history of it.
I'm not so sure of that, but
Well, you might have handled more 1983 cases than me, so I'll back off on certainly and just suggest that it's a possibility. But let's get to another issue with the
I take it, Mr. Clark, that Chief Judge Pratt did not say on the record in this case that her resolution of this particular guideline issue was not decisive. I put a lot of negatives in that question, but
yeah, I'm sorry. Could you please rephrase?
She did not indicate that the sentence did not depend on this guideline issue.
Correct. There's no harmlessness issue in that I would have imposed, I think it's 48 months, regardless of this. There's nothing like that in the transcript. And I also
48 months had been the sentence the last time he'd impersonated a police officer?
I thought it was 41.
Okay.
I think it was 48 this time.
Okay.
I could be wrong on that. I also want to point out that Beckles is tricky because an offender can be punished for engaging in protected speech. During allocution, if the offender says, I'll do it again, under 3553A, that's going to go to future dangerousness, and you can increase a person's sentence for engaging in protected speech. And so in terms of line drawing, I feel like Beckles is the safer route to say that, generally speaking, you can't reach through this broad guideline to attack the validity of state statutes under the First Amendment. briefly dealing with overbreadth, the hypotheticals we've talked about them briefly not being realistic or substantial. I'd like to simply point out that I don't think we've had a hypothetical yet where someone is engaging in protected speech. In the hypothetical that my esteemed colleague posed at the lectern, in that situation, Mr. Hancock had not intended to deceive the officer who knocked on his door. He, as I understood it, immediately said, "I'm not a police officer," and so there's no intent to deceive. And to overturn the finding in this case that Mr. Hancock had an intent to deceive would require clear error, as that's a factual finding, and I don't see any basis to say that Judge Pratt had engaged in any clear error in finding by a preponderance that he had an intent to deceive. And I also would like to point out that on the factual basis, which was repeated in the transcript, in paragraph 1, this is Criminal Doc 79, the Avon police were advised that an individual later identified as the defendant who had been using fraudulent checks at multiple Costco locations was at the store with a law enforcement badge and a firearm on his person. So again, in this case, the reason why police officers were called was because of the gun and the badge. He had been using fraudulent checks, although we don't know the timing in terms of whether it was all that day or not, but I can't see how that matters in the slightest. And I would like to point out one more thing. In the jury instruction and in the statute, there is a basis for a level, I believe, a class 6 felony, a high-level felony for people who represent law enforcement and Department of Revenue employees. In the Department of Revenue section of the statute, it requires the Department of Revenue statute employee to be engaged in collecting property. So, the Indiana legislature knows how to write a statute that requires an affirmative act, collects property from any person. They chose not to do this under this subsection. So unless there are any questions from the panel, I thank you for your time.
Mm-hmm. Thank you, counsel. Ms. Ramey, anything further?
Just a couple of quick points on rebuttal, Your Honors. I'd like to respond to my colleague here. When it certainly causing confusion could be a problem when you're dressed as a police officer, but merely passively resembling a police officer does not rise to the level of making an affirmative representation that should carry felony penalties. The Bonin court was clear, saying that Mr. Bonin, like the statute was constitutional because they sought to deceive, sought to cause a deceived person to follow some course he would not have pursued, but for the conduct. In Bonin, that the individual had sought to deceive a movie audience to tolerate disruptive behavior and sought to deceive police into not taking action. In every other instance of any case that has been cited in all the briefing, someone has intended to alter conduct or obtain something that they weren't entitled to. It doesn't necessarily have to be material gain. It doesn't have to be financial benefit. But they are trying to get something that they're not entitled to.
I guess
There's no evidence in
the problem that you've posed for us, in essence, seems to me the nearly inevitable response of others in public to the gun, the badge, the uniform.
Being, I guess, what, Your Honor? I mean, if I see
as a sufficient representation with sufficiently dangerous consequences or potential consequences that it would merit criminal treatment.
Your Honor, I suppose, I mean, anyone carrying around a gun in public has presents
That's a different
danger.
issue. That's a different
Yeah,
issue.
so
Because if you're doing that and you're carrying a badge, you're communicating a whole lot else
Right.
about your training, your responsibilities, the assistance you may be able to provide to a civilian in need, and so on.
Sure, and if someone approaches you and asks for that assistance and you immediately say, oh no, I'm not a cop. Which is effectively what he did. I mean, I understand that that's not an ideal situation, but does that rise to an affirmative representation?
What good does it serve to be able to say he can do this?
It's a mere lie. And I think that that's what it really comes down to. Under the government's reading of the statute, it's criminalizing mere lies. And the Alvarez court and this court has said you can't do that.
But one that poses dangers that a lie about a Congressional Medal of Honor does not.
I don't know that, I mean, there is some potential dangers in that potentially people could be confused and ask for help, I guess. I guess I'm unclear as to what the added danger is posed by the individual. So, okay. Thank you, Your
Thank you,
Honors.
counsel. The case is taken under advisement. Our next case for argument this morning is Novit against the School District of Warren Township. Mr. Land.
Good morning, Your Honors, and may it please the Court. My name is Matthew Land, and I represent the Novits, both the minor child, E.N., and his parent in this case against the school district, as just mentioned. This appeal was brought by us, the Novits, for a pretty discrete issue. It was to challenge the ruling under Fry, whether or not there needed to be exhaustion under the IDEA to be able to bring other claims under the ADA or Section 503.
Mr. Land, going to that point,
504, I'm sorry.
on counts 2 and 4, is the concession on page 10 of your brief footnote 1 that consistent with Perez, the district court handled those correctly by resolving them against your clients?
That consistent with Perez, that any sort of non-compensatory damages should be conceded. Is that what you're referring to?
Well, I'm asking whether or not you believe counts 2 and 4 survive after the summary judgment ruling by the district court.
We believe that the counts for the Section 504 violations, the ADA violations, as well as the 1983 derivative actions do survive.
I'm tracking you by the counts in the amended complaint, which albeit was filed in Marion County Superior Court. As I read footnote 1 on page 10 of your principal brief, you concede that consistent with Perez, direct IDEA claims should be dismissed for a failure to exhaust. Is that correct?
Yes, Your Honor, that is correct. That is correct. Because the IDEA does not allow for any sort of damages outside of I would call them equitable damages. They do not allow for compensatory damages. Because of that, then a direct IDEA claim would not lie after Perez. So yes, we concede that a direct IDEA claim would not survive even under Perez.
And then as we move to count 5, are you arguing that after Perez, a component of count 5 continues as a result of a request for compensatory damages under Section 1983?
Yes, Your Honor, we are still maintaining that position, that a derivative action under the IDEA it may survive under Perez.
And you hold the same, you're putting forth the same argument with regard to count 6 and 7, the Rehabilitation Act and the Americans with Disability Act?
Correct, Your Honor. Correct, Your Honor. Anything that is seeking compensatory damages under Perez requires no exhaustion. That is our position, and we believe it is as simple as that.
Well, so you think Perez overruled Fry, which holds otherwise?
What was that, Your Honor? The last part? I apologize.
Do you think Perez overruled Fry?
Your Honor, I believe parts of Fry may have bearing. The gravamen test may have bearing in a question where Perez states if there are other damages being sought, then that may be a different question. That one little line that Justice Gorsuch adds there may survive something from Fry, but it seems to be a pretty much a wholesale overturning or rereading.
Well, there is a
of Fry.
problem for you, is there not? Where does Perez say it's overruling Fry or disagreeing with Fry at all?
Well, it doesn't necessarily need to disagree with Fry,
Right.
other
Look,
than
let me tell you what my problem is.
Sure, Your Honor.
The Supreme Court says over and over that we must follow, we, judges of an inferior court,
Yes,
must follow its decisions, even if we think more recent decisions are incompatible with or hard to reconcile with the earlier decision. Right? We must and leave to the Supreme Court the overruling of its own decisions. Perez didn't say it was overruling Fry, so we are required to follow Fry. Can we rule in your favor while still following Fry?
Yes, Your Honor. There is so as Justice Gorsuch goes through in his analysis in Perez.
No. I want you to talk about Fry, not about Perez, because you agree Perez didn't say it was overruling Fry. Now, I'm asking, is your position consistent with Fry?
I believe that Perez and Fry can be read consistently
I'm
together.
asking you a concrete question and would really appreciate it if you answered the question I asked rather than the question you wish I had asked.
I apologize, Your Honor. I thought I was attempting to do that. Yes, we can win under Fry. It just has to be the understanding of Fry. There was a circuit split in Fry with how you apply the gravamen test. The answer in some...
Well, let me ask this question in a different way.
Okay.
Would you have a federal claim if the IDEA had never been enacted?
There are claims under the ADA for the denial of a FAPE, but if the IDEA...
I wish you'd use real words. FAPE is not a word in the English language.
You're correct.
And it is also an acronym associated with the IDEA. So the question I'm asking you is, would you have a federal claim under any other statute if the IDEA had never been enacted?
It's not a question that I have contemplated up to now, Your Honor.
Well, that's what you need to engage. The central feature of Perez is the IDEA claim had been settled and dropped out. It was gone. I'm asking you to consider what happens in this case if the IDEA is gone. Do you have a claim?
I don't see how this case would be any different than the Perez case in which the IDEA claim was gone as well, under your
Well,
reading.
what federal statute requires bus monitors or requires bus monitors to be trained in the administration of particular drugs?
The IDEA.
That requirement came from the IDEA. It came from the individual plan under the IDEA. Is there any other federal statute that creates the requirement that you're relying on?
Not that I am aware of, Your Honor.
Right. So your claim is 100% dependent on the IDEA. Doesn't that create a problem for you?
I'm not sure how it distinguishes us from Perez, Your Honor.
There was no IDEA claim in Perez. It had been settled. It was gone. If you had made and settled an IDEA claim, would you have anything left under any other federal statute? I think you just answered, no, you would not.
Well, Your Honor, I would ask where the claims in Perez would have arisen without the IDEA, even after it was settled. Here we're in a similar situation where it is contemplated that you can bring an ADA claim, you can bring a Section 504 claim for the denial of FAPE.
For the denial of what?
For the denial of free access to public education. I apologize, Your Honor.
No, that acronym means free appropriate
Free
public
appropriate
education.
public
That's
education.
one reason why you need to think in words and not in acronyms.
Yes, Your Honor, I understand. It is our position that our case is squarely on point with Perez, that there is clear language in Perez that the IDEA exhaustion, administrative exhaustion does not need to occur in order for you to bring other claims that are available.
Maybe it would be helpful to distinguish between the exhaustion issue and the merits of those claims. I understand your position that Perez relieves you of a need to exhaust.
Yes, Your Honor.
But then that still takes us back, as I understand the questioning, to whether you violate the ADA and the Rehabilitation Act by failing on one occasion to comply with a provision in an individual education plan adopted under the IDEA.
Yes, Your Honor. Okay. We'll go to failure to provide reasonable accommodations for one. That requires either bad faith or gross misjudgment. As cited by my colleagues, the Eighth Circuit has given us a rule for how to determine what is gross misjudgment. A court ought to look to determine if the actions depart grossly from accepted standards among educational professionals. That's in Monaghan v. Nebraska. We have put forward evidence that the actions of the school that day, there's an 83-page expert report from Dr. Bluth, who is a special needs transportation consultant of the National Association of Pupil Transportation, that this indeed does amount to a gross deviation from industry standards.
So I haven't read Dr. Bluth's report yet.
Yes, Your Honor.
What do you think the school district should have done when the regular bus monitor who has the training doesn't show up for work?
In an instance where you have a child who is in as grave of danger as Ian was in this case, you should at the very least call the parents and say, "Hey, would you like us to put your child on this bus or not?" And I mean that's
And what was the alternative? The parents come pick him up?
Yes, Your Honor. That is correct. And then, in Dr. Bluth's expert testimony, she says over and over that the school's failure to follow its emergency procedures was contrary to safe school transportation industry widely accepted emergency safety policies. She goes on to say that in over 42 years of specializing in special education and special needs transportation, she has known of no other instance, without exception, like this one. And so we have reached the...
Do I understand correctly, you are not alleging intentional discrimination or intentional wrongdoing here?
There was no intentional act to hurt Ian. That is not. That is absolutely.
You're
correct.
relying on deliberate indifference or this other, misjudgment with the pejorative term "gross" added to it.
Yes, Your Honor, as the case law establishes.
Can I ask you also? There's some debate about, at least in my mind, about the status of counts 2 and 4, which is I understand to be asserting under state law that you have a negligence per se claim based on the federal statutory violations, correct?
Yes, Your Honor, that is correct.
Okay, so those are state law claims.
That the negligence per se is a state law claim. Yes, Your Honor.
Only supplemental jurisdiction in federal court on those.
That is correct.
Okay. And the defense has invited you to explain to us how there could be a 1983 claim in this case on a couple of grounds. One is, where's there a policy that would satisfy Monell?
Yes, Your Honor. The school district has a policy, and we have deposition testimony from the Director of Transportation, Ms. Storm, that says that it is the school's policy to replace bus monitors without regard to their training or ability to assist in special needs transportation. That is a policy, and that policy, while followed, given our expert testimony on transportation, shows that deviates grossly from what the industry standards are.
We have another issue, and that is the status of our precedent in Marie O. against Edgar on the availability of Section 1983 to enforce IDEA.
Yes, sir.
Can you point us to any other circuits that still agree with us on that point?
I cannot point you to any other circuits that still agree with you on the IDEA portion, Your Honor. But as an initial point, I would like to mention that our ADA derivative action, the 1983 ADA action, was never raised at this. No objection was raised to it at the summary judgment or brought on appeal. So that argument would be.
Wait a minute. What? Sorry.
When
you keep calling it a derivative 1983 action, I don't understand what that is. I understand stockholder derivative actions, sort of. Okay.
Apologies. The ADA 1983 action, that
ADA 1983.
Yes,
okay,
yes,
I understand that.
When we
But
claim,
what about the Individuals with Disabilities Education Act claim?
The only thing point that we have on that, Your Honor, is that while that was not the initial point of this appeal and was not ruled on by the district court, this court does not have the advantage of having a district court ruling and full briefing on that subject, and it may be better left for another case.
A district court is going to have, along the lines that Judge Easterbrook was discussing earlier, is going to have to follow Marie O. But it seems if we're the lonely outlier on this issue at this point in the federal courts, that's something that we may need to clean up, and that's an issue of law. If you have a brief response on the merits of that, I'd entertain it with my colleagues' indulgence.
I see that we're already out of time.
As long as we're asking questions, you can keep giving answers.
Yes, Your Honor. I would say that on the IDEA claim, the 1983 IDEA claim, given the stature of the other circuits, we would just leave that to the wisdom of this court to determine how it would like to proceed as concerns the 1983 claim for the IDEA itself, not the other 1983 claims.
Mr. Land, I'm a little confused in your colloquy with Judge Hamilton on count 7. That's the Americans with Disability Act claim.
Yes, Your Honor.
That was resolved by Judge Pratt, correct, Chief Judge Pratt?
That was resolved by Judge Pratt insofar as we weren't allowed to bring any claims whatsoever because the exhaustion was not done under the IDEA. Under the old Fry rule that was the conception of this circuit, not other circuits.
Correct. So your argument isn't that count 7, the Americans with Disability Act claim, was not resolved. It was because a record was made, for example, on count 8, the substantive due process. There was evidence put in the record. Ultimately, the district court's decision was on the exhaustion question and didn't engage in a summary judgment analysis as to whether there's a genuine material fact with regard to that particular substantive due process claim. But that didn't mean that the judgment here didn't include the Americans with Disability Act claim. It did, correct?
It did include it insofar as it found that those claims were precluded under the then prevailing understanding of Fry in this circuit. But as I was attempting to say, Perez adopted the other circuit's understanding of Fry in that it is only about what damages you are seeking, and that's the end of the analysis. If there are no further questions.
Thank you, Mr. Land. Ms. Billingsley.
May it please the court. My name is Jessica Billingsley, and I represent appellate, the Metropolitan School District of Warren Township. Today, I urge this court to affirm the decisions of the district court for 2 reasons. First, the Supreme Court's decision in Perez does not affect the district court's decision to grant the school's motion for partial summary judgment. And second, in the alternative, even if Perez does apply, without any material facts in dispute, this court should affirm the lower court on the substance of appellant's federal claims.
The district court here, however, resolved things based upon exhaustion. And I understand your desire to have us do a summary judgment analysis on our own, air quotes. But could you engage with the argument with regard to exhaustion and why you believe your colleague is incorrect?
Yes, Your Honor. The Perez decision and the holding in Perez is that when plaintiffs bring a claim under another federal law, other than the Individuals with Disabilities in Education Act, for failure to provide a free, appropriate public education, FAPE, and those plaintiffs only seek compensatory damages, then exhaustion is not required. That is not the case we have here. Here, appellants brought direct IDEA claims and claims under other federal statutes premised exclusively on the failure to provide a free, appropriate public education. And thus, Perez does not dictate the outcome or apply. Instead, the analysis set out in Fry versus Napoleon's 2017 case applies. And that is the analysis, the question of what is the gravamen of the claims, that the lower court did to come to the conclusion exhaustion was required here. In addition, as Judge Easterbrook highlighted, the facts of the Perez case are distinguishable from the facts at present. There, the plaintiffs in Perez sought to exhaust their administrative remedies through a special education due process hearing process, settling on the eve of hearing, and settling all of the Individuals with Disabilities in Education Act claims. Only then did the plaintiffs bring a claim under the Americans with Disabilities Act for discrimination in federal court. Distinguishable from here, where appellants have never attempted to exhaust administrative remedies under the Individuals with Disabilities in Education Act. And finally, this interpretation or application of Perez in the Fry case is the best way to read both cases complementary rather than contradictory. Because Fry tells us that plaintiffs cannot avoid exhaustion under the IDEA, the Individuals with Disabilities in Education Act, simply by pleading other statutes. And they left open in the Fry versus Napoleon case the situation where claims are brought under federal statutes seeking only compensatory damages. But Perez only answers part of that question left open by footnote 4 in the Fry versus Napoleon case. It does not address the situation we have at present here, and therefore the Perez case does not determine the exhaustion requirement the Fry analysis, the gravamen analysis does.
Let's assume, I'm sorry, go ahead. Let's assume we agree with you on counts 2 and 4, 5 through 7. However, what about this count 8, the substantive due process, and ultimately the third element of shocking the conscience? There's a factual record plaintiffs have made here with regard to the activities that the school district engaged in. Substantive due process would normally use as a vehicle, Section 1983. I certainly understand the gravamen argument about Fry and how that's going to apply to what the claim is, but how would your thinking that you've so articulately given us here today apply to count 8, the substantive due process?
So if we skip over exhaustion and go directly to the substance, I think first I would highlight the fact that the lower court determined that the appellant's statement of material facts in dispute was stricken in its entirety. So to the extent there are no facts in the record or evidence that appellants can cite to create a genuine issue of material fact for summary judgment purposes. And they have not appealed that decision by the district court. Additionally, with regard to the shocking of the conscious third element of that substantive due process claim, this court has stated a King ex rel King versus East St. Louis in 2007 that if there is an opportunity to really deliberate about the decision, then the standard is deliberate indifference. But when it's a hurried decision and there's not an opportunity to really think about the decision, then it must rise to malice or intentional infliction of injury, which appellants admit they do not allege intentional infliction of injury here. Additionally, they don't address this additional standard with regards to substantive due process in their briefing. Instead, they describe their interpretation of facts and cite to an expert opinion, which ironically, if you read those citations, refers only to the negligence standard, saying there was a foreseeable risk of harm, which this course has said in either case is insufficient to demonstrate conduct that shocked the conscience. So for those reasons, whether or not we allow them to cite to evidence in the record that was stricken by the district court, the substance of that claim still comes out in favor of the school district.
Well, the plaintiffs didn't have a reason to, I take it, object to the striking in their opening brief because they were challenging only the exhaustion. You're the ones who put the merits in front of us in case you don't convince us about Perez. I'd like to go back to your treatment of Perez, though. If I understand it, you seem to be saying that the presence of the unexhausted IDEA claim is in essence a poison pill that prevents the district court from considering otherwise independent claims under other statutes.
That is one aspect, Your Honor. The other aspect is that all the other claims are premised or have the gravamen of a failure to provide a free, appropriate public education.
Okay, well, let's take them one at a time. I don't see any basis for what I'm calling the poison pill theory. Can you point us to something that, some legal principle or precedent? Why would it be a good idea to impose that penalty for bringing one unexhausted claim among others that could otherwise proceed?
No legal precedent, Your Honor. Instead, I think it's a reading of the Perez decision with the Frye decision, that the Frye decision left in footnote 4 that opening for we're not addressing the situation where claims are premised on a free, appropriate public education or the failure to provide and seek only compensatory damages. And then Perez did not address the situation where an IDEA direct claim, Individuals with Disabilities in Education Act direct claim, is brought. And so it's a reading of those two cases together that leaves open this gap for an interpretation that if there's an IDEA direct claim, that is, it's not a poison pill in the sense that we still are required to go through the analysis Frye puts forth before exhaustion is required. But given and going through that secondary process, not meaning to jump ahead if you have a secondary question there, that the gravamen of all the claims still relies upon a failure to provide a free, appropriate public education, then exhaustion is required.
So suppose a school district or other government agency takes it upon itself to provide transportation to an adult who is vulnerable to seizures as this child was. Would a failure to provide appropriate monitoring to keep that transportation safe be potentially actionable under the Rehab Act or the ADA?
Yes, it could be. A couple of distinctions there first, Your Honor. First, the Individuals with Disabilities in Education Act can provide services to a student up until they reach age 23. So you could have an adult that has an IDEA, Individuals with Disabilities in Education Act claim. Secondary, if it's a...
No, I think Judge Hamilton was asking the same question that I asked Mr. Land. If the IDEA had never been enacted, could there be a claim under the Rehabilitation Act, for example? And I heard you answer yes, right? That if the public agency had undertaken to provide transportation, but then bungled the job, could there be a claim under the Rehabilitation Act?
Under these facts, Your Honor, no.
I'm not asking about these facts, right? You understand why these are called hypothetical questions?
Yes.
Right. So, please.
Yes, there is a way to plead a claim under the Americans with Disabilities Act for a situation where a school agrees to provide transportation to an adult.
Okay.
That would be, say, an employee who requires reasonable accommodations.
Mm-hmm.
That type of situation would allow for plaintiffs to file a claim under the Americans with Disabilities Act. However, that claim is not based upon the failure to provide a free, appropriate public education.
Right. Here, I understand the plaintiffs to be alleging forget about our IEP in part, I mean, it's on some of the claims. Forget about the individual educational program. What the school district did here was first negligent by providing transportation under these circumstances to somebody facing these risks, and at least arguably worse than that because of failure to provide training to the bus monitor, it amounted to gross misjudgment or deliberate indifference to the risks to this individual, regardless of his age, regardless of IEP coverage.
I respectfully disagree. I believe I heard my colleague here state that they would not have a claim if the IDEA was not available.
Well, I'm asking you. I'm frankly a little confused about who's arguing what, and once there are enough moving parts in this appeal, and most of them presented in your alternative grounds for affirmance, since Perez seems to have blown the water out of the exhaustion theory. But so help me out.
So the question being, can appellants maintain claims under other statutes besides the
The
individuals with
ADA
disabilities?
and the Rehab Act.
The answer is yes, they can, but on the substance, they do not prevail. So looking at example,
So that's where you want us to basically do the work in the first instance of evaluating the experts' reports and deciding whether there's enough to go to a jury on a theory of either gross misjudgment or deliberate indifference.
first, Your Honor, I don't believe that analysis is required here, given the fact that appellant's statement of material facts in dispute was stricken at the district court level. So there are no facts in evidence, no material facts in dispute. And the facts,
Why was that stricken?
it was stricken for failure to comply with Local Rule 56-1, which requires appellants to state the specific facts in dispute and cite to evidence in the record that shows those facts are in dispute. Appellants failed to comply with that, and so Judge Pratt determined that their statement of material facts should be stricken in its entirety, and appellee's statement of facts was admitted as undisputed.
Appendix 12 and 13.
Yes, Your Honor.
And then Judge Pratt goes on and says, even if the 56-1 statement were not stricken, the court would still conclude there are no genuine material fact to preclude a termination of Warren Township's motion for partial summary judgment.
Yes, Your Honor. And so without any material facts in dispute, asking this court to affirm on alternative grounds is not as large of a task as it may have been, though the court is permitted to do so under Box versus APT Company, 7th Circuit, 1985, assuming that appellants have had sufficient opportunity to present evidence and an argument in the record. Also briefly touch on school's position is that 1983 is not an enforcement vehicle available for the Individuals with Disabilities in Education Act, nor for Section 504. And that is admittedly in contradiction to this court's Murillo decision. However, the Murillo decision was decided 8 years before the Supreme Court's decision in Ranchos Palos Verdes, which gave further direction on how to determine if Section 1983 enforcement is available. There, Ranchos Palos Verdes and the Supreme Court described that you look at the language of the statute and the comprehensive enforcement scheme, if there is one. Both the IDEA and the Section 504 have comprehensive enforcement schemes. The Individuals with Disabilities Education Act has the exhaustion remedies we've been discussing today. Section 504 adopts Title VI enforcement procedures, which this court has already held are sufficient and comprehensive enough to exclude 1983 enforcement. And with regard to the Individuals with Disabilities in Education Act, the statutory language itself prohibits use of 1983, as it only discusses the Constitution, the Americans with Disabilities Act, the Rehabilitation Act, and any other laws enforcing or protecting children with disabilities.
Does the same apply to the Americans with Disability Act, count 7?
No, it does not, Your Honor.
And why not?
The Americans with Disabilities Act does not have a comprehensive enforcement scheme, and the statute itself does not speak to the remedies or the enforcement available. Thank you.
Thank you, counsel. The case is taken under advisement. We will hear argument next in the case of United States against Claiborne. Ms. Eisenman.
Thank you. May it please the court, Vanessa Eisenman on behalf of Ricky Claiborne. This case should be remanded for a limited purpose, and that is to allow the district court to reconsider the sentence just on the robbery counts in light of the newly enacted retroactive amendment to the status points guideline. There really isn't a whole lot that's in dispute here. Everybody agrees that the district court made no error in the guidelines initially, and everybody agrees that the status points amendment changes Mr. Claiborne's guidelines such that he now has a lower criminal history category and a lower guideline range under the amendment. In this case, this court's decision in United States versus Alexander addresses these exact same circumstances and says that the proper course of action is to remand to the district court for it to consider if it would change the sentence unless the record indicates that it would have imposed the exact same sentence. Here, the government doesn't even argue that the district court would have imposed the same sentence, and it's all over the record that the judge chose this 168-month sentence because it was at the bottom of the guideline range. He even says, I'm going to choose a bottom of the guideline sentence. The government asked for that sentence because it was at the low end of the guideline, so there is nothing in the record to indicate that the judge would not reconsider based on the lower guidelines. Again, this court has authority not only under that discussion in Alexander.
Did the guidelines as they took effect on November 1 contain an express retroactivity declaration?
Believe that's under the 1B 1.10 is where it includes Amendment 821 and says that that is included under the retroactivity provisions.
Because your reply brief doesn't say that.
Oh.
Your reply brief says that the chairman wanted it to be retroactive.
I apologize.
What's needed is an express retroactivity finding by the commission.
Yes, and that was made, and I apologize that it
I'll
wasn't
ask
in the
the
brief.
same question of the United States, whose brief obviously preceded some of these events, right? That's the big question. Is there an express retroactivity finding by the commission?
Yes. And even if, I want to rely on that, but even if we did, when we filed our opening brief, there wasn't, and there is still authority in this court.
Well, it doesn't matter what happened when you filed your opening brief. What matters is whether the commission has declared this amendment to be retroactive.
They have.
No, not whether the chairman wants it to be retroactive, whether the commission has made it retroactive.
I understand. I apologize for the error. Yes, it has.
And which amendment was that?
That's Amendment 821 is the status points amendment, and then it appears, the retroactivity portion of it appears in guideline, I believe it's 1B 1.10.
So there was an amendment to 1B 1.10.
And if you'll indulge me just for a second, that is in the appendix to my reply brief. I apologize that it was not clear. So that's on Appendix 36 in my reply brief, 1B 1.10. And it's subsection E, special instructions. The court shall, the subsection before that is D, covered amendments. There it lists 821, and subsection E is where it talks about the effective date being February 1st. But again, the district court has authority to have these kinds of proceedings under 3582 even before that point, as long as the order is not effective until then.
Ms. Eisman, we'd have discretion to address this under 28 U.S.C. 2106. Mr. Claiborne would have the opportunity to pursue other avenues of relief as well, 18 U.S.C. 3582C. Why should we use 2106 and not leave him to his other devices?
Yeah, I think that's a good question, and the answer is because you can, and it would be the most efficient and expedient thing. We're already here. We're already on appeal. This court has precedent in the Bell case and also in Alexander to use 2106 in these kind of situations, and that is also a situation in which Mr. Claiborne would be assured his constitutional right to counsel. Under the Blake decision, he does not have that constitutional right under 3582. So again, we're here, we've got authority, we've got case law. There's no reason not to just do it now. Give him the relief that he's entitled to, let him go back, rather than having him start all over in a 3582 proceeding. So unless this court has any questions, I'll reserve my remaining time for rebuttal. Thank you.
Mm-hmm.
Good morning.
Ms. Mavis, you can tell where we're going to start.
Yes, good morning, Your Honor. May it please the court, Jessica Mavis for the United States. Your Honors, the government submits that no error was committed, and to remand this case for modification.
No, I said you can tell where we're going to start.
I can.
Has the amendment been expressly listed as retroactive?
Yes, Your Honor. The government has no basis to object to the applicability of the amended guideline or the retroactivity to defendant Claiborne. However,
Keep going. Go ahead.
the government's position is to remand this case pursuant to 2106 is not proper because this court would then be making a finding that the district court's sentence was unjust or inappropriate. And defendant can point to no error. There's no plain error. No error was committed by the district court when sentencing defendant Claiborne. The judge correctly calculated the sentencing guidelines at the time he sentenced.
Why do you care whether we remand, whether instructions to think about Amendment 821, or whether Claiborne files a motion in the district court asking it to think about Amendment 821? In either event, the district judge has to do it.
Understandably, Your Honor, but the government cares about whether or not this court tells the district court that a sentence that was proper was unjust or inappropriate, because it wasn't.
I understand that, and frankly, I came in thinking there was utterly no basis to remand in this case. But since the amendment has been declared now retroactive, why doesn't that amount to a plain error since we apply controlling law as of the time of the appeal in making that determination?
Well, Your Honor, the remedy afforded to defendant under 3582C is specifically dictated for this purpose. When a guideline amendment results in a lower sentencing guidelines range.
Right, you agree that's available to it?
Correct.
Okay, so, okay.
And that is the proper vehicle. That is the proper vehicle for all defendants.
You haven't answered my question. Why do you care?
Because the district court sentence was just and it was appropriate.
Well, you're going to say the district judge should not reduce the sentence. Why do you care whether you say that on remand or in response to the absolutely inevitable motion to reduce the sentence in the district court? It's the same question for the same judge at one might think the same time.
Your Honor, the government can't take a position yet with respect to what the government's sentencing recommendation would be under a 3582C petition. That being said, the remedy that is afforded to defendant under 3582C is not a full rehearing or resentencing on the robbery counts, which is what defendant asks for under 2106 with counsel. 3582C does not afford defendant counsel, but there is a general order that has been entered in this district that does afford defendants who desire to have counsel appointed on 3582C petitions to have counsel from the Federal Defenders Program appointed if they so desire.
So my colleague's argument that Claiborne won't have counsel is moot at this point. Defendant Claiborne will have counsel if he so desires on a 3582C.
Okay, so you don't want to bully him, right? On the theory that he won't have counsel, but that still leaves us with the problem, what difference does it make to you?
The issue is the properness of the procedure, Your Honor. Under 2106, Defendant Claiborne gets more than he's entitled to. He gets more than every
How
other
so?
defendant.
How so?
He gets a full resentencing or a full hearing on the robbery counts, on 4 counts that every other defendant doesn't get under 3582 who is similarly situated.
I don't
to Defendant
understand
Claiborne.
what the difference is.
So under 2106, this court is number one finding that the sentence was unjust or inappropriate and remands to the district court,
We don't have to find that a sentence
No.
was unjust in order to remand.
or that the court committed an error.
No, we don't have to find that either. We can act under 2106 as we think justice requires. That's what the statute says.
And then the nature of the hearing is more than what Defendant Claiborne is entitled to or any other similarly situated defendant under 3582C.
So your argument is that somehow the other sentences have a possibility of being adjusted under 2106 that doesn't exist under 3582?
They have a more robust hearing. Under 3582C, we're dealing with a briefing schedule, right? So a defendant
Why can't
files-
we remand and say, conduct the same kind of hearing you would conduct if there were a motion?
if there were to be a hearing, I'm not under 3582C. My
I
understanding.
think you underestimate the scope of flexibility given by 2106.
Where the government's position is that 2106 requires that this court find that the district court committed an error. And defendant cannot point.
Where is that in the language of 2106? What am I missing?
Under 2106, the court may affirm, modify, vacate, set aside, or reverse, and remand, and direct appropriate judgment as may be just.
Yes.
And those are the words.
It doesn't say if the district judge committed an error at the time it was, and so on. It's just not there.
But the standard of review for a claim that defendant didn't raise at the time of sentencing is plain error review. And there is no error in this case.
No, it's not plain error review. There was no error. We're all agreed on that. There was no error. But we have a retroactive guideline, and the question is, what is the most appropriate way to proceed in the absence of error, but with the presence of a retroactive guideline? And I still don't see the answer to why the United States gives 2 hoots.
You know,
The district judge has to consider the retroactive guideline, and it's perfectly free to say, don't make no difference to me, thank you very much.
The district court certainly can, under consideration under 3582C, which is the appropriate vehicle for the district court to consider the amended guidelines and the reduced guideline sentencing range. So if there are no further questions, the government asks this court to affirm the judgment of the district court, finding that 3582C is the appropriate mechanism for the defendant to submit his request to the district court. Thank you.
Thank you, counsel. Anything further, Ms. Eisenman?
No, thank you.
Okay. Well, thank you very much. And Ms. Eisenman, the court appreciates your willingness to accept the appointment and your assistance to the court as well as your client. The case is taken under advisement. Bertro against Kishikazi is our next case. Mr. Duncan.
Good morning, Your Honors. May it please the court. Dana Duncan on behalf of Eric Bertrand. This case comes before the court on one single issue. And the length of this oral argument will be based in part on that one single issue. It could go on for a few minutes or it could go on for the entire length of my allotted time. But It's whether the ALJ has a duty of inquiry and a duty to develop the record in this particular case. The commissioner's position is that because the ALJ asked counsel if the record was complete and he said it was, that's sufficient. And the Supreme Court in Bestick has already discussed the fact there are no categorical rules. If you look at the case law on the duty to develop the record that exists throughout the 34, 40 years of Social Security disability jurisprudence, the cases that have been denied on the duty to develop the record have been such things where it's a minor medical issue or something that the record did not adequately develop. What we have here is plain and simple 5 years of missing records. And what was the obligation or what was the responsibility of the ALJ?
What do you think an ALJ is supposed to do when the lawyer for the claimant is asked, is the record complete, and says yes? Is the ALJ supposed to say, well, counsel, I'm assuming you're a liar. I'm just going to proceed on that assumption?
Doesn't need to say that, Your Honor. What he needs to do, though, is go, Mr. Bertrand.
He needs to proceed as if he's a liar without saying that to his face.
Correct. Because that's part of his duty.
That can't be right.
But that's the duty. These are informal hearings. Now, we have no question that if he's not represented by counsel, that he has greater latitude and greater responsibilities to inquire. The only thing we're asking in this case is the ALJ simply said, counsel, I've noticed that there are no records after 2015. This hearing is in 2020. Did he get treatment during that period of time? Because, quite frankly, in the few hundred hearings I have in a given year, administrative law judges will often ask about the fact that there's a reference to an MRI, but there's no MRI in the record. And then you have to address it. That kind of thing in and of itself would not trigger the duty. But we have 800 pages of additional records that are in this case. And it's relevant because not only is it we're talking about his Title II benefits with a date last insured in 2016, but the fact that he also was eligible for SSI benefits going forward. Now,
So let me make sure that I understand, Mr. Duncan, because
Yep.
your briefs were not at all clear on this, even in response to the government's response brief.
yes,
But we're not limited to 2016.
no, because the decision itself included SSI benefits and a decision on SSI benefits, which would have been up through the date of the hearing itself. But as far as foreclosure, if he loses this, then his Title II benefits cannot be claimed at any point
Understood.
unless he gets reinsured.
But it's a little, I mean, frankly, it's a little hard to see a lot of medical evidence, particularly self-reported, which is what almost all this is, I think, self-reported symptoms from 2017, 18, 19, and 20 affecting an analysis meaningfully of his status in 2016.
But the problem with that, Your Honor, is that once you've established that there's a duty to defend or to develop the record, it's not this court's responsibility to weigh that evidence. That's Social Security's job.
Well,
and
that's
it's a harmless error
you are proposing a totally unworkable standard here. At least it seems to me, I don't understand any difference in the standard you're proposing and the standard that we would apply to an unrepresented claimant. Is there any practical difference?
No, but the standard of review for harmless error.
So you're
is
arguing there's a
frivolous.
bright line rule
No.
that says even if counsel says the record is complete, then the ALJ has failed if you later turn up records that were missing.
No. What we're talking about is not a bright line rule. It's not a categorical rule. It is a rule that's based upon reason. If we're talking about 3 months of missing records, no. If we're talking about a missing report here or there, no. What we're talking about is 5 years of records where the file just stops. I mean, there's at least an obligation at that point for the ALJ to make an inquiry as to why the record just stops. Did he not have treatment? Social Security ruling SSR 16-3P clearly indicates the judge is supposed to inquire about the failure to follow prescribed treatment. So he's going to have to ask what this prescribed treatment was. If he's not going to do that, how is he supposed to determine if he stopped treatment, for example, because of lack of insurance or ability to afford the treatment itself? So there is an obligation that extends beyond. And it's not going to be something that is going to automatically, in every case, trigger. But when you reach a point where there's 5 years and 800 pages of records pertaining to his migraine headaches, and the judge's final determination is, well, he must have gotten better because there's not really enough evidence here to say he's continuing to have them and getting treated for it.
Is that your argument on prejudice? I'm trying to factor in how the prejudice argument comes in.
Correct. There's enough evidence there. The standard for harmless error either is my position is frivolous, or there's a reasonableness that on remand, an ALJ may come to a different conclusion. You have to be certain that that different conclusion would exist. And looking at this evidence, while I admit it's not like an MRI or an X-ray, it's still, when you have migraine headaches, it's not easy to provide objective evidence of a migraine headache other than to have the
Mr. Duncan,
electronics attached.
what about the possibility of affirming with respect to disability insurance benefits and remanding as to the time actually covered for the for supplemental security income?
The only problem with that, Your Honor, is because of the fact that this court, as its sister courts have done, is that there's retroactive medical opinions and medical records. So in other words, records from 2017 and 2018 can be used in conjunction with
Sure, in theory.
Sure.
But we're looking at a specific record, and if I understand this correctly, the plaintiff was in 2016 was surfing. Is that right?
Yeah, I guess. I mean, yes.
I've never seen that in a disability claimant before.
I've seen a lot of bizarre things, Your Honor, through the years. And usually what ends up happening is you'll find things where they'll do something like that, and then afterwards the medical records show they really shouldn't have been doing that because they ended up doing a lot more damage to their health than they thought. But, yes. So, I guess the point being is, and I go back to the fact that these are supposedly informal hearings, and what the purpose is of an informal hearing. I mean, we have this very loose substantial evidence standard because of the fact that these are informal hearings. And as a result, the judges have a duty. I remember in the days when I started this 30-some years ago, the judges would sit down and tell you what they're finding in the record and what evidence they think's missing and what they think would help develop the case. Now we've gotten into this much more formalistic method, and we have waivers and forfeitures and and all this.
But you have one of the largest adjudicative systems in the world.
Yes.
It has to be with an incredible caseload per ALJ, and you seem to be saying they can never finish.
No, that's not exactly the case. Because,
except by finding disability.
No. No, that's not what I'm saying, because in this particular case, we're not asking to update the record for a few weeks or a few months or to continue to regularly update the record through until the decision's issued. What we're asking is that the duty to develop the record should include a simple request when there is a gap of 5 years?
Okay.
Why are
Thank you,
those
Mr.
records
Duncan.
missing? Thank you.
Ms. Kuntz.
Good morning, Your Honors. May it please the Court, Elaine Kuntz on behalf of the Acting Commissioner of Social Security. I would like to begin by clarifying what the agency's and the ALJ's duties here are in developing the record. The regulations in Section 1512 set out a shared responsibility to gather evidence. So under subsection B, the agency has the responsibility to develop a complete medical record, which the regulations define as a medical record for at least 12 months preceding the date of the application. The regulations then very clearly shift the burden onto the claimant to provide any updated medical evidence. Under subsection A, the regulations state that the claimant must inform the agency about or submit all evidence known to the claimant that relates to whether or not the claimant is disabled, and the duty is ongoing and requires the claimant to disclose any additional related evidence about which the claimant becomes aware.
Ms.
There's-
Kuntz, could I ask you to address the point in the plaintiff's reply brief at page 12 with in the middle of the page, he says the SSA website provides the form with the following cover page instructions. You do not need to ask doctors or hospitals for any medical records that you do not already have. With your permission, we will request your records. The information that you give us on this report tells us where to request your medical and other records.
So that form and the instructions in that form do not alter the regulatory burden in any way. What that form is saying is that it's filled out right at the beginning of the application process as an information gathering tool, and the form says, if you tell us what your medical sources are at this time, we will request that evidence. And that is what the regulations say under subsection B. We will gather the medical evidence for the 12 months preceding the date of the application. But there is nothing on that form that says going forward, we're going to continue carrying that burden for you. Now, separate from the regulations, cases have recognized the non-adversarial nature of the Social Security system, and they have created a limited expansion of this duty to develop the record. This is almost exclusively applied to unrepresented claimants or those with severe mental impairments or cognitive disabilities who are not able to develop the record on their own. The facts of this case do not create that sort of heightened burden that for the ALJ to develop the record. Not only did Berteau have an attorney here, he had hired that attorney more than 4 years before the date of this last ALJ hearing and decision. This case had been remanded by the Appeals Council twice, and after both remands, Berteau's attorney updated the medical record. And significantly, the ALJ asked the attorney if the record was complete, if he had had a chance to review the record, and the attorney said the record is complete to the best of my knowledge. Under these facts, there are no special circumstances that would enhance the ALJ's duty, and there is no question here that the agency satisfied its duty under the regulations to develop this record. So the court's review of this case can end at the duty question and find that the ALJ satisfied the duty to develop the record and no further inquiry is necessary. Turning briefly to the second question, if the court does reach the question of prejudice, a review of the supplemental record shows that there is nothing in this record that was reasonably likely to change the outcome of the ALJ's decision. As we laid out in our brief, these records are often duplicative, and they show Berteau making the same subjective symptom complaints that he made throughout the original record. There are no objective findings or new treatment that would corroborate Berteau's subjective complaints. And significantly, as we pointed out, these supplemental records show that Berteau performed a much wider range of daily activities than he had originally testified to. In addition to the surfing, we have records showing that he was boxing and jump roping, And 5 months after the decision was issued, Berteau told his physical therapist that he was helping a friend move furniture upstairs with no issue. So here, because the ALJ took all necessary steps to develop the record, and because Berteau has not demonstrated that the supplemental record was reasonably likely to call into question any of the ALJ's findings, if the court has no further questions.
I actually do.
Sure.
Let me start with, it's actually relevant for both sides, but we had other things to talk about with Mr. Duncan. Why is everybody citing so many non-precedential orders of this court as if they were precedents?
Because there is very few published case law on this issue.
Well, the way you make that point is to make that point explicitly. Maybe drop a footnote to some non-precedential orders if you can't resist the temptation, and then to invite us to issue a precedential opinion on the subject. What's your best Seventh Circuit precedent on the scope of the ALJ's duty to develop the record from your point of view?
The closest published case we have here is Johnson v. Barnhart. That was the 2006 case where the court found that an ALJ was entitled to rely on the statement from a pro se claimant that there were no outstanding medical records. Even the court found there that even a pro se litigant bears some responsibility for making a record. And I think the reasonable expansion of that case, the reasonable next step would be that a claimant who is represented by an attorney bears even a greater responsibility for making the record, and the ALJ is more entitled to rely on the representations of an attorney.
So, yet it sounds like there's still a duty on the part of the ALJ, right?
So there's no regulatory duty. What we're arguing is under the facts of this case, there was no greater duty at the hearing for the ALJ to step in and develop the record at all. We're not asking for any sort of bright line rule, and I don't think we need to reach the question of a bright line rule. I think the facts here lay out pretty clearly that the ALJ's actions were reasonable in relying on the representations of the attorney.
Even with the 5-year gap?
Yes. I think it's also important to keep in mind the nature of Berteau's impairment here. I think saying 5-year gap, saying 800 pages of medical records sounds bad, but if you look at the record that was before the ALJ, he had this injury in 2013 and then 2.5 years of no answers. And he's reporting all of the same symptoms, and no one is able to tell him what's happening. And at the second hearing and the third hearing, Berteau says, my impairment has not changed over the past 5 years. At the second hearing, he said he's not seeing Dr. Sherrill monthly anymore. He's not taking any medications. He's not treating his migraines in any way. And he was not receiving any mental health treatment. So you have Berteau's testimony that nothing has changed. I'm not receiving any treatment. So a 5-year gap doesn't sound unreasonable under those specific circumstances. The court has no further questions. We will rest on our brief and ask that you affirm the ALJ's decision. Thank you.
Thank you very much. The case is taken under advisement. Our final argument of the day is Rogers against Rankin. Mr. Casserblad.
May it please the court. My name is Jared Casserblad, and I represent Richard Rogers, who is asking this court to reverse the district court's decision to grant Dr. Rankin summary judgment and to reverse the district court's dismissal of Drs. Foss and Youssef at the screening stage. Mr. Rogers entered the Illinois Department of Corrections with an objectively serious medical.
Before we get into this constitutional argument, I have a simple question. Are you making a malpractice claim under state law?
No.
Why not?
I don't know. I couldn't answer that. Why? though?
You're the plaintiff's lawyer. You have to know the answer to that question.
I don't know why, when the complaint was filed pro se. And
I understand that. And then he had appointed counsel, well, recruited counsel in the district court. But I'm asking you, you pick up these papers, which look like they might be a malpractice claim, and you argue only the Constitution of the United States. Why didn't you ask us to remand to consider a malpractice claim?
Well, we didn't ask the court to remand to consider a malpractice claim because one wasn't brought. So
You don't plead law, right? Pleadings plead grievances. They don't plead legal theories, right? It might be that the plaintiff was mistaken or his prior lawyer was mistaken, but I don't see why you should think that the failure to assert a particular legal theory sets a boundary on the case when it reaches the Court of Appeals. In any event, there is no malpractice claim, so let's proceed.
thank you, Judge. So he entered the Illinois Department of Corrections with an objectively serious medical need. He had scoliosis and surgically implanted metal rods in his back. When he first met Dr. Rankin, Dr. Rankin became aware that he had been diagnosed by doctors with that condition and that it mandated treatment. And any layperson would know that someone with surgically implanted metal rods in their back requires the care of a medical person who understands that condition.
Counsel, when does the responsibility shift from the initial radiologist to Dr. Rankin? It strikes me that it's a tougher argument to say that the responsibility here falls on Dr. Rankin, given the fact that Dr. Rankin is rejecting the conclusion of one radiology and asking to go back and saying, hey, I read these x-rays differently. There really is a problem with his hardware.
So the responsibility always lied with Dr. Rankin from December of 2016 onward, when Dr. Rankin confronted a medical situation that he did not understand, did not know, and did not appreciate. And at all relevant times, Dr. Rankin should have been referring Mr. Rogers to a specialist because that need was made obvious by Dr. Rankin's own ignorance of what Mr. Rogers' symptoms meant, what treatment to provide him, and what decisions should be made as appropriate for Mr. Rogers' care. Mr. Rogers informed Dr. Rankin directly that he was at high risk for spinal fractures and hardware breakage, and told Dr. Rankin that he'd had 3 prior incidences of that occurring, and other physicians had recommended annual imaging. In that respect, the district court erred by finding that Dr. Rankin was free to exercise his own independent medical judgment and not give Mr. Rogers what he wanted and not follow the advice of other physicians, because Dr. Rankin had no medical basis to be rendering a decision like that.
What advice of other physicians are you referring to?
The need to get annual imaging to evaluate degradation of the spine.
What other physician had advised Rankin that that was required?
No physician advised him of that.
Exactly. Rogers said that to Rankin.
Right.
Right. If you want to say that a physician has to follow other physicians' advice, you've got to provide that advice. Prisoners and plaintiffs in general will say the wildest things about their conditions. You're not suggesting that every physician is required by the federal Constitution to believe everything a prisoner says about medicine, are you?
No, of course not.
All right. So why should Rankin have paid any attention to what Rogers was saying as opposed to what, say, Yusuf and Foss were saying?
Well, to begin with, Dr. Rankin, let me answer that question twofold. In the beginning, in December of 2016, the x-rays had not been taken. And Dr. Rankin admits that Mr. Rogers was already experiencing tenderness in the spine. There's a complaint in June of 2017 that the district court does not cite in her opinion, but made by Mr. Rogers to Dr. Rankin about irregular sensations in his spine and following up on his request to see a specialist because he thought something was wrong with it. And the reason that Dr. Rankin is not entitled to rely on the radiologist is because he admits he didn't. He says that he understood from the x-rays that the report was inconclusive and that he continued not to know what was wrong with Mr. Rogers' back, but he could physically observe a bulge in the area where the hardware was located. And he knew that he was having extreme amounts of pain, but he didn't know why. And he chose, instead of following up with other imaging, continuing to letting him see a specialist who would have known what those symptoms meant under this peculiar condition and circumstances, he chose, what he claims he chose is he chose to monitor plaintiff's condition moving forward because he didn't know what was wrong. The problem with his claim is that there's no evidence in the record that any monitoring was actually done. And in fact, after the plaintiff's expert reviewed the records, there was a well-reasoned opinion that Dr. Rankin created a clinically inaccurate medical history about Mr. Rogers' care. And there are disputes of fact in the record about the nature, frequency, and extent of the complaints that Mr. Rogers has made. And if we assume that he made the complaints he claims.
So what is the evidence indicating that the medical records are not complete or correct?
If plaintiff is correct that he made the complaints that he did.
I'm asking that question, do we have that from plaintiff in the form of testimony?
You have that in the form of an expert opinion that explains the basis of it, who reviewed all of the records and found that.
So there is no such testimony from the plaintiff?
Right, the plaintiff did not look at his own records and say that they were accurate. Inaccurate.
Did the plaintiff testify about encounters with Dr. Rankin that are documented inconsistently with the plaintiff's testimony?
Yes.
Where?
There are. In the grievances that were submitted, Mr. Rogers explains that throughout the course of the period from 2016 through.
Are the grievances under oath?
The grievances are not under oath.
Okay.
The grievances are his statements about what happened. There was no deposition taken of the plaintiff, but I can't recall exactly what the cases are on that, but my understanding is that it's appropriate to submit evidence from the plaintiff about what his expected testimony would be.
He can do that?
Yeah.
In the form of sworn affidavits?
Well, to the extent that the court's not going to credit the statements that he made in his grievances about his treatment by Dr. Rankin, or consider those as evidence of what he would testify to, that is.
This is not a difficult question.
Uh-huh.
But it doesn't sound like those are evidence that the plaintiff himself can use.
Well, I'm not sure that any objection was made to any of those records being used at summary judgment at all, in which case those kinds of issues would have been addressed in the district court. But the evidence from Mr. Rogers is that he made complaints, and the district court credited that testimony. She simply held that and assumed that Mr. Rogers made those complaints in other clinics at other times and would not consider those complaints in connection with the claim because she said that those complaints were not urgent. But they all add up to a body of evidence that Dr. Rankin was turning a blind eye to what was quickly becoming a very serious problem for Mr. Rogers, who spent over a year and a half with broken metal rods scraping against his flesh. And I can see that I'm running out of time, and I would like to save at least 15 seconds for rebuttal.
Certainly, counsel.
Thank you.
You've got 10. Mr. Drinkline.
Thank you, and may it please the court, Chris Drinkline, and I represent the radiologists, Drs. Youssef and Foss. Plaintiffs specifically alleged that the radiologists committed malpractice when they evaluated and misread his x-rays. These allegations are insufficient to state a Section 1983 deliberate indifference claim.
I have something of the same question for you. You, too, are proceeding as if complaints plead law or legal theories. Complaints plead grievances. They might identify facts. If a plaintiff, a prisoner who's never even been to law school, uses a word malpractice, that doesn't confine or limit the case in any way. Why should it matter?
I understand that this morning more than ever, and I think the answer is
It's not simply this morning more than ever. It's that the Supreme Court has held this repeatedly.
Rule 8 requires a short and plain statement of the claim.
Of the claim, not of the legal basis for the claim.
Right. And any sins in construing the complaint incorrectly, Your Honor, are forgiven by the express explanation in the district court's merit review order that he had the discretion to allow amendment on good cause shown or under Federal Rule of Civil Procedure 15. And yet, even after having taken the depositions of the radiologists, even after having retained counsel, if there was sufficient facts revealed in the deposition to bring claims for deliberate indifference, then he could have and should have moved to amend his complaint in order to state a claim for deliberate indifference.
It sounds like you're arguing once again that you have to plead law in the complaint. You plead a grievance, and then in later papers in the district court, you might articulate a legal theory behind the grievance. You do not plead law. It's a simple proposition.
And I understand that, Your Honor, but the merit review order was over and done with based on the district court's construction of the complaint as only bringing Section 1983 deliberate indifference claims. And with an opportunity to correct that if that was not his intent, although we heard this morning that it's not his intent now and it wasn't his intent then, to bring a medical malpractice.
No. Mr. Casaglad said that he was not pursuing a malpractice theory. He did not purport to have access to the intent of Mr. Rogers, as if that mattered.
Right.
I'm sorry. Let's just proceed.
Plaintiff's contention regarding the facts
Intention is irrelevant. Maybe I can't desist. The question is whether a claim has been pleaded. What's in people's heads is not the subject of notice under Rule 8 or Rule 12.
And plaintiff had the opportunity to explain that to Judge Baker if that's a mistake that he made, and he didn't afford himself of that opportunity despite the express explanation that he could. He should have said, no, Your Honor, I'm trying to proceed under a medical malpractice claim. Or, no, Your Honor, I'm trying to proceed.
You're saying he should have been clearer about what law he was pleading. And I'm saying, according to the Supreme Court of the United States, complaints don't plead law. They don't have to. They plead grievances. Law comes later.
I heard you, Your Honor. And the other component, however, is where you make a specific allegation of negligence, like they did in this case. They evaluated the x-rays and they misread them. That's a specific factual allegation of negligence. That's inconsistent with a deliberate indifference mental state. So said this court in the Antonelli v. Sheehan case. In his reply brief, the plaintiff highlights the wrong standard, suggesting that citing pre-Bell Atlantic v. Twombly authority urges this court to apply the old Connolly v. Gibson no set of facts standard to conclude that the district court erred in dismissing his claims. According to the plaintiff, it's possible that the radiologist did not even read the x-rays, and it's possible that they intentionally, if they did read them, intentionally misrepresented their findings. But it's clear that in the wake of this court's decisions in both Lovano and Arnett v. Webster make clear that the plausibility standard applies to 1915 review
Yes,
of pro
thank
se
you, counsel.
complaints. Your Honor.
Your time has expired, counsel.
Thank you, Judge.
Mr. Jeanette.
Good morning, Your Honor. May it please the court, Peter Jeanette for Dr. William Rankin. I would like to address a couple of the comments made by plaintiff's counsel. He suggested that the first x-ray in May 2018 was inconclusive. That was not true. That was discussed with Dr. Rankin during his deposition, and he was very clear that the x-ray was not inconclusive, that it was conclusive to him. The x-ray indicated that the Harrington rods, the report indicated at that time that the Harrington rods were intact and in the proper anatomic position as they would be expected to be.
And the rough time frame for that is?
That was in May of 2018. There was obviously a second x-ray later that showed the breaks more clearly, and if you have the advantage of that second x-ray, you can look at where the breaks are at that one and go back to the first one and find a very small discontinuity in one of the rods.
Although Dr. Rankin is the one who discovered that, not the initial radiologist.
In the second x-ray, that's correct. And that discontinuity kind of brings me to one of the other comments in plaintiff's reply that I want to address, that he's indicated that there is a bulge in the muscles that was ignored. And if you go to Dr. Rankin's testimony, so that pages 50 and 51 of his deposition, he was talking about there being a prominence in the muscle along his spine. And plaintiff's counsel asked him what he meant by that. He described that as, well, it just bulges out a little bit. And so plaintiff's counsel has tried to read that as there's some hardware sticking out causing a bulge, which is not the case. No one has said that. And if you look at the x-rays from 2018, you'll be clear to anyone that that would not be the case. It's a very tiny discontinuity at that point in time. Plaintiff's counsel has also accused Dr. Rankin of creating a false record regarding the May 2018 visit. And I pressed Dr. Harrington about that assertion in his deposition around beginning of page 48. And what he said was that the May 2018 note by Dr. Rankin indicated that he was been complaining of back pain for several months. And he claims that that note was false because it did not indicate that he had chronic back pain. And I went through with Dr. Harrington that Dr. Rankin had been seeing him since 2016 for chronic back pain, that the record was replete with documentation of that chronic back pain and the medications that Dr. Rankin had prescribed for him. So that was not a false record, and I want to be very clear about that. The characterization of Dr. Rankin as deliberately indifferent in this case, I think, is it can't be more incorrect. He should be the hero of the story, not the villain. He is the one who found this error in the second x-ray, who got the treatment that he needed, and up to that point in time managed his pain as best he could. Whenever a complaint was made about his pain, he adjusted medications, and we've kind of set that forth in the record.
The list of medications for Mr. Rankin, or for Mr. Rogers rather, seems unusually long for prisoners with chronic pain.
He had a number of ongoing conditions, including hepatitis and hypertension, for which he was treated, and importantly, for which he was seen on a regular basis. If you look at Dr. Rankin's deposition beginning around page 86, he goes through some of those other visits, and on most of those visits, Mr. Rogers did not make any complaints about his back pain. Occasionally he would, and it would be addressed. On at least one of the visits, he said that the gabapentin that had been added to at a previous visit was helping him during the day. So that was something that was raised regularly with him. Mr. Rogers also saw nurses twice a day because he was receiving med pass. He had the ability to submit sick calls at any time. So he had the ability to raise more issues with his back if he needed to, as far as the pain management. And Dr. Harrington, plaintiff's expert himself, said he did not take any issue with the medications that were prescribed. His only issue was the pain, was the lack of referral. And at no point was Dr. Rankin actually aware of any problem with the Harrington rods prior to that October 2019 x-ray, So he could not be deliberately indifferent to a condition if he was not actually aware of that, and that's fairly clear from the case law.
How old was Mr. Rogers between 2016 and 2022?
I apologize, I don't recall that off the top of my head. I want to say he's a middle-aged guy. I don't think he was particularly young or particularly old.
And just so we get the sequence correct, after Dr. Rankin corrects the second set of x-rays, he then refers to an orthopod who refers to a neurologist.
Correct.
And then Dr. Rankin continues the recommendations, the consultations with the specialists. Is that correct?
That's correct, and I don't think there's really any criticism of the treatment from October going forward. There was some suggestion at some point that he should have been referred to a neurologist initially, but if you look at Mr. Rogers' grievances, his initial procedure was done at Midwest Orthopedics at Rush, so the orthopedic was certainly an appropriate consideration at that time.
And the collegial review that was necessary here, if I understood the calendar, took place over one business day.
They took place very
Friday the
promptly,
13th.
and all of his were approved.
I've had my issues with Wexford's procedures from time to time, but that one stood out, particularly since Friday the 13th of March 2020 was a pretty memorable day for all of us.
Yes, I think so. But they did move promptly on all of those, and if it makes you feel better, Judge, I believe they have gotten rid of the collegial review process.
Okay.
Thank you, Your Honor.
Thank you.
Thank you very much. Mr. Cossaglad, I'll give you 2 minutes for rebuttal.
I'd like to address two things with those 2 minutes. The first is that Dr. Rankin's conclusion that the plaintiff suffered from chronic pain is not consistent with the reports of pain that he received from Mr. Rogers, which were at all times acute in nature with recent onsets within a matter of weeks or months that gave him trouble sleeping and eating, etc.
So a matter of degree, you're saying?
No, I'm saying chronic pain is pain that is persisted for a long period of time. It does not appear to abate. Acute pain is something that comes on recently, and this is a patient who knew what broken hardware felt like in his back and told the doctor that that's what it felt like because he knew what he was experiencing.
Does the record indicate how many times his hardware had broken previous to incarceration?
3.
Thank you.
And I would just call this court's attention to page 62 of Dr. Rankin's transcript, where he expressly says that he understood that the radiologists were not claiming that nothing was wrong with his Harrington rods. He understood from the report the x-ray was not telling him what the cause was. And a patient with metal rods in their back who's reporting that it feels like it's broken, a specialist was made obviously necessary, consistent with this court's opinion in Barry v. Lutzy. If there are no further questions.
Thank you very much, counsel.
Thank you.
The case is taken under advisement, and the court will be in recess.